When can you sue the FBI? The Houston Valladares case, Martin versus the United States, and the future of federal accountability. My name is Abdul Faruqi. I'm a former federal prosecutor, and now I do personal injury work, specifically helping people who have been injured, both by private citizens and by the government. And today we're dealing with a critical question that affects every American. When can you sue the federal government when its agents make catastrophic mistakes? So, two cases here that caught my attention because we know about a month ago there was a verdict in Houston involving the family of Ulysses Valladares that they got about $2 million after an FBI agent fatally shot him during a botched rescue. And after hearing about that case, I heard that the Supreme Court is preparing to hear another case, Martin versus the United States, which could fundamentally reshape when the FBI can be held accountable for their actions. In this case, that's before the Supreme Court. It's raiding the wrong house. In both cases, we're going to examine the legal principles at play and understand why most lawyers and most agents get these cases wrong. If you're handling one of these cases, I hope you stick around. I'm going to share some strategies that typically are not going to be talked about on blogs. And definitely in law school textbooks, you may have heard about these concepts, but it's a real jurisdictional maze that makes or breaks these claims. So the Houston Valladares case, first let's look at what happened in Houston. In January of 2018, Mr. Valladares was kidnapped from his Conroe home in front of his 12-year-old son. During an FBI rescue operation, one of the agents fired through a window and they killed Valladares, who was bound and blindfolded. Now, during these cases, there's all kind of claims made. The agent claimed that Valladares grabbed his rifle. This was a story that federal judge Kenneth Hoyt found as an intentional falsehood in his March 2025 ruling. And that's a really serious thing for a federal judge to say, and that likely may have ended that agent's career. The autopsy report, which was properly introduced as evidence, showed no close-range firing, which directly contradicted the agent's account. Judge Hoyt found the agent was negligent, even grossly negligent, and awarded the family nearly $2 million. And that is one example of a case where gross negligence is going to be the decision maker, and also just the agent's credibility was. That's incredible to make one story that the evidence showed was not true at all. What's exceptional about this case is that it survived through multiple procedural obstacles over 7 years. It survived a qualified immunity challenge, which is almost unheard of with FBI agents, when Judge Hoyt found the agent's actions were objectively unreasonable and ruled that all reasonable officers would have known that the act of shooting blindly through a window at an unidentified person violates the Constitution. Most critically for practitioners, this case showcases the importance of expert testimony, establishing the standard FBI breach protocol, and proving deviation from it. Families Counsel in this case effectively demonstrated this wasn't about policy or discretion. It was about the fundamental operational failure that violated the FBI's own standards. So you got policy or discretion on one side, and then you have operational failure. And what you really want is to prove operational failure in order for your case to survive. And it helps. It helps that the judge believes your case. And in these types of cases, federal judges hear them, and depending on which federal judge you get, I guess that really depends on the outcome of your case. The Martin case is the one in Georgia. So Martin versus the United States is scheduled for oral argument. As of the time of this recording, is scheduled tomorrow. I'm recording this on April 28th, 2025. It's scheduled for argument April 29th, 2025. In that case, in October 2017, FBI agents raided Martin's Atlanta home looking for a suspect named Joseph Riley. They detonated a flash grenade, broke the door, and pointed the guns at Martin, her partner, and her 7-year-old son. But the problem is that they were at the wrong house. Riley lived a block away, and one address was 3741 Landau Lane. That's where the FBI was supposed to go. They ended up at 3756 Denville Trace. The FBI had the wrong house, and a mistake that would have been caught by even rudimentary address verification protocols. These search warrants, I've drafted these search warrants before, and we just don't go by address. We put a description of the building, the color, like the number of stories, if there's a car parked outside. So, when these cases catch national attention, there's usually something really egregious about it. Um, in this case, how could they have missed this? But they do miss it, and this is what makes lawsuits. So anyways, thankfully, nobody died in this case. The Martin family suffered trauma, lost wages, needed therapy, and they sued. The 11th Circuit Court of Appeals dismissed their case, ruling the decisions about executing warrants fall under the discretionary function exception to the Federal Tort Claims Act. Um, for me, that seems like an operational decision. But what's fascinating here is that the 11th Circuit created an insurmountable standard by holding that since the FBI did not have stringent policies or procedures in place that dictate how agents are to prepare for warrant executions, their actions were discretionary. So this creates a perverse incentive for agencies to avoid creating clear protocols, because the fewer guidelines they have, the more shield from liability they enjoy. So, it's interesting, like, to rule this way basically means don't give officers directions or instructions, and then whatever they do is based on whatever they feel like is appropriate, which gives them a lot of latitude, but invites a lot of opportunities for errors to occur. And, I've worked in government agencies where there are no clear policies and procedures, and so when you're trying to do the right thing, you are just ending up using your judgment and somebody else uses a different metric, and so everyone's making different decisions based on what they think is right, and there's no consistency in the outcome. So that is also probably one of the problems with the government, having worked in it, is this desire not to put too many things in writing. At least some people feel that way. This is the 11th Circuit, so we'll see what the Supreme Court has to say about this. The Supreme Court is going to decide two critical questions. One, does the Supremacy Clause bar FTCA claims when federal employees' actions have some nexus with furthering federal policy? And does the discretionary function exception shield agents from liability from wrong house raids? For attorneys handling these cases, here's a strategic point. The circuit split on these questions is stark. Had Martin lived in Illinois instead of Georgia, for example, her case would have certainly proceeded through the 7th Circuit, and geographic lottery shouldn't determine justice. So really, depending on where you live, Judge Hoyt's decision was in the 5th Circuit, which I'm trying to remember off the top of my head. I think it's either the 10th or 11th Circuit. That was the offshoot of the 5th Circuit. But anyways, it really does matter which circuit you live in, just like which state you live in, and that's just kind of the consequence of federalism. The Federal Tort Claims Act, these cases involve basically an exception to immunity. The Federal Tort Claims Act was passed in 1946 to provide remedies when federal employees cause harm. It waives sovereign immunity, allows citizens to sue the government, but there are exceptions, the biggest one being this discretionary function exception under 28 U.S.C. Section 2680A. This shields the government from liability when employees exercise discretion to further policy objectives. And what people know about this is that there's a 1974 amendment to the FTCA that came after the infamous Collinsville raids. Federal narcotics agents raided the wrong houses in Illinois, terrorizing innocent families, and Congress specifically added the law enforcement proviso to 28 U.S.C. Section 2680H to ensure that victims of such raids could seek redress. But the technical language that most attorneys miss in these raids is that the law enforcement proviso explicitly permits claims for assault, battery, false imprisonment, false arrest, abuse of process, or malicious prosecution arising from acts of federal law enforcement officers. What's critical is that these intentional torts are exempt from the discretionary function exception, a point that's consistently missed by government defense counsel and sometimes by the courts. So why did the Valladares family win while the Martin family's case got dismissed? It's all about framing and jurisdictional interpretation, and this is where litigation strategy becomes crucial. So what's the discretionary part versus the operational part that comes to this? In Valladares, Judge Hoyt found that the agent's actions were operational failures, so firing blindly through a window isn't a policy decision. But this finding didn't come easy. It required a methodical evidentiary development through discovery and expert testimony establishing FBI breach protocols. But in Martin, the 11th Circuit framed the agent's actions as discretionary. Decisions about executing a warrant, even at the wrong house, were deemed protected, and that's where the case went sideways. So, what successful FTCA claims require early and aggressive framing of the government's conduct. You have to atomize the conduct into discrete acts. We're not just talking broadly what the government did. We're talking about minute by minute, individual by individual. The decision to conduct the raid, that's going to be discretionary. And they call it a raid, a search, whatever you want to call it. But, whether to have one or not, that's a discretionary function. The execution, the inadequate address verification, who was going to staff it, what time of day were they going to do, what kind of preparation work did they do. They have operational reports for these. They have operational briefings as well. And, the process by which they do this, that's all operational. These are things that you can attack. There are two key precedents that most attorneys are going to miss in these: Berkowitz versus the United States versus Galber, which established a two-part test for the discretionary function. First, did the conduct involve an element of judgment, and second, was that judgment based on considerations of public policy? You have to specifically plead facts negating both elements. So it's not enough to prove your case. You have to actually plead it in such a way that you're negating any exceptions the government may rely on. And so one of the things you can do in these kinds of cases is use Freedom of Information Act requests to get agency internal policies and manuals. And if the agent violated those protocols, you've neutralized the discretionary function exception because there was no lawful discretion to violate mandatory directives. Meaning if there's an instruction to, for example, have a certain number of people staffed to set up a perimeter, or a certain number of people to work this thing, and they say like every raid requires 2 individuals that are going to be directing traffic or something like that, and if they don't have that, then that's not a discretionary function, that's an operational failure. So, these cases, especially the Martin case that's coming up before the Supreme Court, has attracted significant bipartisan attention. We have senators that are interested in this, Senators Rand Paul, Ron Wyden, and Cynthia Lummis, along with Representatives Harriet Hageman, Nikema Williams, Thomas Massey, and Dan Bishop. They filed an amicus brief urging the Supreme Court to hear the case, and the argument leverages the separation of powers principles. Congress specifically amended the FTCA to cover wrong house raids, and the 11th Circuit decision nullifies a law enforcement proviso in that circumstance. So, when Congress passes a law basically saying we want the government to be held accountable for this, and the judiciary is rewriting that law so that the government cannot be, it seems to subvert congressional intent. This intervention is unique. It explicitly references the 1973 Collinsville raids that prompted that proviso. It's a powerful legislative intent argument that directly counters the government's interpretation. I've heard about this happening in Texas, where legislators are trying to pass laws, trying to have parts of it to explain why they're passing the law. And there are certain people in the judiciary who are saying, we don't care about what the legislative intent is, we're just going to look at the plain meaning of the language and interpret it from there. And I think it's important for us to know why laws are passed in the first place, to be able to interpret how to apply them. I think just looking at the plain language without context does a disservice, and it makes it very difficult to have fair and effective outcomes. So for people who are litigating these kind of cases, the judicial branch should not be creating immunity where Congress has specifically waived it. And this separation of powers framework is useful to counter jurisdictional defenses, arguing expansive judicial interpretations of immunity effectively amount to judicial legislation and contravention of Congress's intent. And sometimes you'll have to make that argument. You may not find a case per se that says that, but essentially you have to go back to the basics of constitutional principles to make that argument. So the takeaway in handling these kind of cases, I think there's about 7 critical takeaways that people need to understand about FTCA litigation, especially when you're suing the government. Try the best you can to frame it as operational and not discretionary. So focus on execution failures, not policy decisions. And take your case and split it into discrete acts, each which can be separately analyzed under the discretionary function test. Whenever I would build up cases, you have actions and you have characters and you have time, and to put on a timeline who's doing what exactly is happening, and trying to analyze whether that's discretionary or operational, that can be really helpful, because there's a lot of facts, a lot of information. You can't expect judges to understand all of it. Even federal judges who have, they're the ones that are going to be hearing your cases, not necessarily jurors. But the judges themselves, even if they have law clerks, it's a lot of information coming at them fast. And, there is a tendency to give discretion and deference to government lawyers who argue these cases because, they have a tendency to be more credible than a plaintiff's lawyer who's trying to collect some kind of contingency fee. But at the same time, what's right is right. And sometimes the government will be vigorous in their advocacy for the government, and sometimes it requires the plaintiff's bar to assure that these things are labeled correctly, because that is a point of contention. The second practice pointer is that your SF-95 administrative claim, there's a lot of technicalities that can kill you there. You have to state a specific damages amount. The some certain requirement is jurisdictional to preserve your legal theories without over-arguing or overreaching. You have to have enough detail to allow the agency to investigate it, but you don't necessarily want to lock yourself into theories that your discovery might undermine. Third principle is that Freedom of Information Act. You got to do them early and you got to do them often. Before you file your lawsuit, obtain the agency's internal policies, protocols, training materials. These are gold. They establish what's mandatory when violated, and that can help you so much in negating any kind of discretionary function immunity. Number 4, expert testimony is essential. You're going to want to retain former agents who can explain standard protocols and identify what are deviations. So you basically need that Monday morning former quarterback who's done that same play and basically explain what happened. In that Valladares case, expert testimony on proper breach protocol was determinative. You can't just walk in a court, have the government put somebody up saying this was reasonable, and then you just cross-examine it without your own evidence. You're going to need your own ammunition on experts. Number 5, challenge the supremacy clause defense head-on. The 11th Circuit application of this doctrine to bar FTCA claims is an outlier position. Emphasize that the FTCA itself is a federal law. There's no federal-state conflict triggering any kind of supremacy clause concerns. Number 6, use 28 U.S.C. Section 2674's private person standard strategically. The FTCA makes the government liable in the same manner to the same extent as a private individual under like circumstances. And so it is kind of more difficult when you're dealing with private persons breaching into someone else's home and deciding when or when not to use weapons. But you can make an analogy to maybe a private security company going in and retrieving property or entering a home, maybe some kind of eviction or something like that. They're going to be super careful they're supposed to be super careful before they enter places, and you just have to find whatever analogy you can to take the halo off of the government's actions and try to bring it back to the reality that how these people might be liable as private citizens. Number 7, know your jurisdictional differences. Identical facts can lead to opposite outcomes depending on the circuit. So while forum shopping isn't an option in FTCA claims, you have to tailor your arguments to the circuit precedents or prepare to challenge them on appeal. So what is going to happen with the Supreme Court case tomorrow? I think the case in Martin can go several ways. The potential outcomes would be, the first scenario, if the court broadly affirms the 11th Circuit, we'll see the discretionary function exception swallow the law enforcement proviso. meaning wrong house raised, similar mistakes can be entirely shielded, and essentially the congressional intent behind the 1974 amendment would be effectively nullified. That I don't see that happening simply because that just seems like such an extreme position for the court to take, even with the current, even with the way the justices are placed. Scenario 2, the court could reject the 11th Circuit Supremacy Clause analysis while preserving some discretionary function immunity. This would create a narrower path for plaintiffs focused on specific operational failures rather than policy decisions. I think that's probably how it's going to end up. They're going to have some of those aspects, but it's going to make it harder for plaintiffs to bring a claim. But scenario 3, and this is kind of the wish list this is the wish for plaintiffs' attorneys, but I don't think this is what's going to happen. Based on recent questioning patterns by Justices Kagan and Barrett, the court could adopt a bright line rule that wrong house raids inherently fall outside the discretionary function exception, that the government has no legitimate discretion to raid the wrong house, full stop. That would be an amazing result. I just don't know if the current makeup of the court would go so far as to do that, but you never know. So the technical issue is to watch how the court handles these cases, because the oral arguments on April 29th will be telling to see how they deal with this. Recently, the court was congratulating a Solicitor General who had argued, I think, 160 times before the Supreme Court, and they were just speaking highly. I think it was Justice Roberts, who, I can't remember the guy's name, congratulated him for his 160th appearance before the court, and that was going to be his last one. Solicitor Generals and people who argue on behalf of the United States have to basically tell the court the way the law is, and sometimes they try to tell the court to change the law. In this case, I think the law is that it is, and it should continue to be this way, that if you're raiding the wrong home, you are liable. I think that seems like such a fundamental error, especially in this context, that liability should attach to the government's actions here. So, the conclusion here is that even if you're an innocent party, you've been kidnapped, you are held hostage, or you're just in your home minding your own business, the government can come and disrupt your life. And then once that happens, they can claim that they're immune from any of that wrongdoing. It seems fundamentally unfair. Valladares, even though there was close to a $2 million settlement, he's left behind a 12-year-old son who not only witnessed his father's kidnapping, but then lost him to the very agency that was trying to rescue him. And, these types of things, of Martin's family, they have a young child in that home, and he had guns pointed at him at age 7. Can you imagine a 7-year-old having to endure that? And certainly kids that go through that kind of stuff get PTSD and other kinds of traumas. These are the costs of operational failures, and for the government to just sweep it under the rug and say, well, we're immune from that, creates a government that's really not by the people or for the people. Having worked in the government, litigating these cases, they fight these cases not just to avoid financial liability, but because of precedential impact. Every successful FTCA claims becomes a template for future accountability, and that's why DOJ typically appeals any significant loss, as they may do with the Valladares judgment. I'm sorry, I haven't tracked that case, so I imagine there's going to be an appeal, but we'll ultimately see what happens with it. My advice for people who are handling these cases, you need a litigation team that has both FTCA specialists. You're definitely going to want some people who are former federal agents that are dealing with these types of cases, meaning they have worked in that position and they can speak credibly about what's expected from them. And then these cases are marathon cases. Valladares took 7 years to resolve, and you have to stick with it the entire way. I think the difficult work, just speaking as a former prosecutor, I think the difficult work law enforcement does is important, but I know accountability isn't the enemy of good policing. I think holding people accountable just raises the standards, and we just have a better society in general. So thanks so much for listening, and until next time, stay vigilant and keep fighting for accountability.